Whether you're a content creator, a documentarian, or a musician, chances are you've heard the term fair use. But what does it really mean? And when can it get you in trouble? I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by my partner, Richard Buckley. We are going to talk about fair use, kind of an overview, one of the most misunderstood doctrines in copyright law, on today's installment of the briefing. Hey, Richard, good to have you back.
It's great to be here. Good to see you, Scott.
Yeah. So today is the first installment in a probably think about four installments, maybe five, of episodes where we're going to talk about basic issues related to intellectual property law or like media and entertainment issues. And the first one that we're going to talk about here is fair use, which we talk a lot about on our podcast, The Briefing. But I don't, we had never given like a very broad kind of approach to fair use and a discussion about the kind of it from a broader spectrum. Usually, our discussion is somewhat granular, related to a particular case. So, we're going to kind of cover the basics. So, let's start with the basics. So, what is fair use? Fair use is a legal doctrine that allows limited use of copyrighted material without permission from the rights holder. And it's codified right in the Copyright Act, Section 107 of the Copyright Act.
Right, Scott. The idea behind fair use is to strike a balance, to protect the rights of creators while also allowing for commentary, criticism, news reporting, teaching, scholarship, research. In other words, it supports free expression and promotes the exchange of ideas.
Right. There are four key factors that courts will look at when deciding whether a use qualifies as a fair use. So the first is the purpose and character of the use, including whether it's commercial and whether it's transformative. Second factor is the nature of the copyrighted work. The third is the amount and substantiality of the portion used. And then the fourth is the effect of the use on the potential market for the original work. So why don't we break those down? Richard, why don't you talk about the first factor?
Sure. The first factor, purpose and character, often gets the most attention. If you're creating something transformative, meaning that you're adding new expression, meaning, or message, that can weigh in favor of fair use. But if your use is purely commercial and does not transform the original, that's a strike against you.
The second factor looks at how creative the original work is. The more creative it is, the more protection it tends to receive. Using a purely factual work might more likely qualify as fair use than a work that is a work of fiction.
The third factor considers how much of the original you used and whether you used the quote unquote heart of the work, even if it was a small portion.
And the fourth factor, and this is a big one, it's about market and market harm. If your use serves as a substitute for the original work or causes market harm, it's very unlikely to be fair use. So let's talk about some examples of fair use. So, one classic example of fair use, and one that seems to get a lot of attention, is parody. In Campbell versus Acuff Rose Music, the Supreme Court found that Two Live Crew's parody of Roy Orbison's Oh Pretty Woman was fair use, even though it was commercial because it was transformative. Fair use also frequently comes up in documentary films, academic publications, and even in the meme culture.
And these days, with creators on YouTube and TikTok using clips from shows and music and movies in commentary or uh, what are called reaction videos, the line is blurrier than ever.
So let's talk about the Andy Warhol case and the limits of fair use. We've talked a lot about Andy Warhol Foundation versus Goldsmith and how that has impacted fair use. So that's a recent and very important case, and it really shook up the fair use landscape. So in that case, Warhol, the Andy Warhol Foundation, had used a photograph by Goldsmith as the basis for a silkscreen portrait of Prince, which was later licensed for use in a periodical. The foundation argued that this use was transformative because Warhol added new meaning and new aesthetics to Goldsmith's photograph.
But the Supreme Court disagreed, holding that even though the work may have looked different, its commercial purpose as a magazine cover undermined a finding of fair use. The court emphasized that transformation alone is not enough.
Yeah, that decision had real implications, especially for artists and creatives who are incorporating existing works into new creations. And it also focused fair use on a new factor, which is the purpose of the copying and whether the purpose of the copying actually justifies the copying. So let's talk about some common misconceptions and some risks of getting fair use incorrect. So here's a few common myths about fair use that, for whatever reason, people think are true, and 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 this can get them into trouble. So the first one I hear all the time is, "I gave credit, so it's fine." So not true. Giving credit does not make fair use. The second one I hear a lot is, well, I only used a couple of seconds of it, 10 seconds, 5 seconds, 3 seconds, whatever. There's no set amount of time that guarantees fair use. It is a factor. The last one, I shouldn't hear this as much as I do, but I still hear it very frequently. It's on the internet, so it's public domain. No, not true. Copyright protection doesn't vanish just because something is posted on the internet or otherwise widely available.
And getting this wrong can be very costly in terms of takedown notices, account bans, lawsuits, and damages.
Yeah, yeah. I mean, this happens more often than it should. And even the cost to settle a small little case where, let's say, it's just a cease and desist letter, uh, you have to get your lawyer involved. And then if you're wrong, you have to pay a settlement, right? And it's thousands and thousands of dollars when a little ounce of prevention could have prevented all of that. All right, let's go over some practical tips for creators.
So, first, if you're relying on fair use, make sure that your use is genuinely transformative and is not competing with the original. Also, always consider whether your work could cause market harm.
And when in doubt, get a license or talk to an attorney. Actually, you should do both. You should talk to an attorney first and then probably get a license. The fair use defense is powerful, but it's very complex and very involved. And it's not something that an untrained person should try to navigate on their own. So thanks again to my co-host, Richard. Richard, always great to have your insights. And thank you, our listener, for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share with your network. We'd also love to hear from you. So leave a comment or a review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.